Mike Bluehair here, co-founder of Film the Police Portland. I have an update on the railroading of Eli Ritchie, the web journalist that was most recently slapped with an anti-stalking order by none other than our police chief, Miss Danielle Outlaw. You see, Miss Outlaw was upset that Ritchie had the courage to approach her in public and ask her questions pertaining to her job. These are the kind of things that you would expect to be going on in a free and open society. Journalists approaching public officials and asking them questions. Something that I noticed when I was attending Eli's stalking hearing was the police testimony was packed full of lies, perjury. A lot of lovely hearsay evidence was admitted into evidence, and it was just a complete sham. I've been chomping at the bit over the last week because I knew I was going to be able to get my hands on the audio transcript of the trial in its entirety so I could expose these sociopaths for the criminals hiding behind uniforms and law and the color of authority of their station to abuse the citizenry. But unfortunately, the audio files that was given to us by the courts were incomplete. So only 20.1 minutes of Eli's trial was actually released to us. To add insult to injury, the presiding judge over Eli's stalking hearing was none other than Adrian Nelson. Judge Nelson was most recently appointed by Governor Kate Brown to the State Appeals Court of Oregon. Personally, I think it's really awesome that we finally have an African American judge in the High Court of Oregon. Congratulations would be in order if it wasn't for the fact that Judge Nelson's hobbies includes moonlit walks on the beach, dog grooming, and the occasional bouts of balling up the Constitution and wiping her backside with it. There's so many glaring examples of unconstitutionality in Eli's stalking hearing that it almost made me weep, and I'm an anarchist. Anarchists don't believe in the legitimacy of government. That said, as a police accountability activist and an advocate for civil rights, I think it's important to point out the fact that the law protects various groups of people in various ways. It's not equal, and it's about just us. Just us and our rich friends, or just us and our connected, hooked up friends, and not you. And that's the way it's always been in this country. That's why I do what I do, and that's why I'm going to point out the flagrant examples of unconstitutionality and perjury and outright crimes, and this is malicious prosecution. When government uses the mechanism of government and the courts to shut down free speech, to shut down journalism, that's tyranny. So that's what I'm standing against. So the first thing I'd like to point out about Eli's trial and the fact that Judge Nelson just jumped up and down on a constitution the first couple minutes in is simply this. The city attorney was representing Miss Outlaw, our police chief, in a stalking hearing. This is a blatant conflict of interest. You see, it's the city's attorney's job to limit liability for the city, meaning their job is to make sure that no one sues the city, and they have to represent the interest of the city of Portland, PDX, not Miss Danielle Outlaw. So, hypothetically, if something were to come out during the trial that would release information to the public that would increase the city of Portland's liability, like some kind of information would come out during the cross-examining of the cops, for instance, that would make it easier for someone to get a lawsuit against the city, the city attorney wouldn't be able to adequately represent Miss Outlaw in that capacity, and she would have to choose between her job as city attorney, which she's contracted to do, or her job as defending Miss Outlaw to the utmost of her ability. And that would be impossible if certain things came out in a trial. So, Judge Nelson sitting there and allowing this to continue is a clear-cut example of her willingness to turn her back on the very Constitution she swore an oath to preserve and defend. So without further ado, let's listen to Judge Nelson strike down Eli's motion to have the city attorney removed because of the flagrant conflict of interest that's inherent to her duties to defend the city against civil liabilities.
So we're going to do the temporary stalking orders first, and then we'll go to the permanent stalking orders. My name is Adrienne Nelson, and I am the judge that will be sitting in this, in managing this docket today. The first thing I'm going to say is because this is a stalking order proceedings, that there will not be any videoing because of the supplemental local rules and the uniform trial court rules. Therefore, anyone who's trying to use any type of device that is prohibited, as well as there is not any public access, so there can't be any video under the SLRs. Okay, so temporary stalking orders are under two statutes, ORS, Oregon Revised Statute 30.866, as well as 163.730. These statutes are very technical, specific, and narrowly construed. It is not a cure-all for all types of unwanted contact, and is not legally available for most types of unwanted contact. But in many cases, if someone is harassing for you, if you can't get a stalking order, it may be more appropriate for you to talk to the police or the district attorney's office. In order for me to issue a temporary stalking protective order, you have to show that there is probable cause to believe that the respondent has intentionally, knowingly, or recklessly engaged in repeated, unwanted contact with you or a member of your immediate family or household, that you were alarmed or coerced by each contact. The alarm or coercion must be objectively reasonable and cause you reasonable apprehension in regarding your personal safety or that of a member of your immediate family or household. If the context involves speech or other types of expression, there is a higher standard that must be met in both the severity and immediacy of the threat because of constitutional protections on freedom and expression. So we have just the one, and I believe it's Outlaw versus Ritchie. Go ahead. You may identify yourself for the record.
I'm sorry, Your Honor. Sorry to interrupt. I'm Ritchie. Do I come to the test?
You should.
Thank you. And since I was wondering too, since Ms. Outlaw, I'm not sure how she likes to be named, I was wondering if I can have a second person come.
You may not. Only attorneys or people who are parties can come.
Thank you. And Your Honor, I do have media as well. If you'd like to view that on
you can. You have
video evidence of the contacts as well.
Oh, we will get to that. All right. All right. Could you put the name on the record? Thank you.
For the record, Rebecca Plaza, from the Attorney's Office. I am here representing Petitioner Danielle Outlaw on the matters that were case for today in case number 17 SK02618.
All right. So,
Can I object at this point?
I was going to ask you if you want to make a statement. You can tell me what you want to say.
I was just going to say, if she's a city...
And you have to stand up
pardon.
when you address the court.
Thank you.
This is a formal proceeding, and you have to act in a formal way. You're going to have to address everyone by their last names. Go ahead.
Okay. From my understanding, a city attorney, it would be a conflict of interest for a city attorney to be representing Ms. Outlaw in this case, since she's a city worker and a police officer, and just from what I understand.
I'm not going to address that. If the city attorney has decided to represent her, he can. You don't have standing to basically say she can't have that representation.
Okay.
Are you saying that you want your own representation?
No, I'm not saying that I want my own representation. I'm just wondering, I as a taxpayer am actually, from what I understand, hoping to fund her bill, her paycheck, and she's representing someone against me. And from what I understand, this is a civil matter, and Ms. Outlaw would be responsible for either representing herself or having the public sector and the private sector represented.
So what I'm going to say to you is that we're here to address the merits of this stalking order.
Mm-hmm.
And that's what we're going to focus on, because we have a very limited time frame, because then we have to move to the permanent stalking orders. If you want to have a more full hearing at a different, other than today, we can set this over. Otherwise, we're moving forward.
We can set it over to a more full hearing? I'm not
No,
quite sure.
I'm saying we have time to do this today. I don't understand what you're wanting. You're not going to get to litigate here whether or not she gets to be represented by the city attorney. What I understand is that there is an application for a stalking order based on unwanted contact, and
Yes.
that's what we're prepared to here to do today. Other issues won't be addressed.
I was just wondering for clarification on the.
Okay, Mr. Ritchie, I think we've done. Okay,
Thank you.
fair enough. Do you have a statement?
Sure.
There you have it, folks. Judge Nelson thinks that conflicts of interest are A-OK. Stay tuned to my next few uploads for the continuation of this lovely stroll down Tyranny Lane. And please do share, upvote, like, spread my lovely message of police accountability all over your Tweety, Facebooky, Instagrams. Just to hit the little icon of the thumb up or the thumb down or whatever's clever. Yep, thanks guys for watching. And if you're watching this on Steam It, hook a brother up with an upvote or maybe even a re-steam for police accountability, because I am your friendly neighborhood cop watcher. I'm out there in the streets filming the cops, so you don't have to.